Good morning, everybody. Welcome to our Travers Smith webinar on off-payroll working this morning. I'm Tim Gilbert. I'm one of the partners in the employment team here, and I'm joined this morning by Mahesh Varia. Mahesh is one of the partners in our tax team and also heads up our incentives and remuneration group. The session this morning is running through to 10:15. We are going to have a recap on the background to the off-payroll rules. We're going to look at some of the thorny, tricky issues that exist in this area, as well as some of the recent changes that have been made to the legislation. And we're also going to look at some of the practical steps that you either will be taking or may be taking as you get ready for April next year. If you have any questions that you'd like to ask as we go through, please do put them into the Q&A box at the bottom of the screen, not the chat box. If you put them into the Q&A box, I'll be monitoring that as we go along. And if I can put questions to Mahesh as we go through the slide deck, I will do. Otherwise, we'll be looking to answer those questions at the end, subject to time. Finally, the session this morning is being recorded, so it will be available if you have any colleagues who you think might find it useful but were unable to attend this morning. And the link to the recording will be coming around to you all after the session, alongside with the slides that we're using today. Okay, so I'll pass over to Mahesh.
Thanks, Tim, and good morning, everyone. Welcome to our session today on the new off-payroll rules. What I wanted to do before I sort of kick off into the main sort of meat of the topic is really discuss or explain how workers provide their services using a personal service company. And if you look at the left-hand side of the slide, you'll see the sort of classic supply chain, and this thematic is going to feature throughout the talk. So it's good that we sort of touch upon it now. So the basic structure whereby an individual wants to provide services to a client using a personal service company is set out here, where you've got the worker at the bottom. The worker sets up a personal service company. That personal service company is in fact what we call an intermediary. It doesn't have to be a company, it could be a partnership or an individual, but in most cases it's a company. And that company provides services to the end client. Quite often there are agencies in the way, and the reason why that's the case is the end client will normally say, I need a particular type of resource. Please could agency one find me a person who can provide me with that particular resource, that particular service. Agency one may or may not be able to do this by itself, and therefore may subcontract the instruction to another agency, agency two. And it's agency two that provides, that engages the PSC, and the effectively that creates the contractual supply chain. So at the bottom we've got the worker, and at the top we've got the end client. So here we are again. I know we've got some people online today who have attended a similar session in the past, discussing the off-payroll rules. So a bit of background as to why the rules are being introduced. Well, the rules are being introduced because HMRC's perception is that contractors who are using a personal services structure, a personal service company structure, are not paying tax in the way they should. Quite often they are providing services which are akin to being employees, but they're being taxed as self-employed persons, and that gives income tax savings to the individual and national insurance savings to the individual as well. And so this is not a new problem HMRC have identified. This is problems that existed for sort of many a year, and HMRC did introduce the IR35 rules to combat this problem. And these rules were introduced nearly 20 years ago. But the problem with the IR35 rules is that the responsibility for adhering to them rests on the personal service company, which from HMRC's perspective is difficult, because it means that the burden rests with them in order to look at each contract of each personal service company in order to attack it, by which I mean in order to try and argue that the payments being made pursuant to the contract should be subject to PAYE income tax and national insurance contributions, instead of effectively self-employed taxes and dividend tax, which is how workers get their money out of their personal service company. So in order to combat this lack of compliance in the revenue's mind, what they've done is introduce the off-payroll rules. And what HMRC expect is that the rules extending to the private sector, they're already in existence and have been for a couple of years now for the public sector, should raise £1.3 billion of additional tax revenue by the tax year 2023-24. And in HMRC's mind, this is not additional revenue. This is revenue that should have been paid if IR35 was properly complied with by personal service companies. But for the reasons I've explained, that obviously hasn't happened. So what are the off-payroll rules? Well, the purpose of the off-payroll rules is that it's the same as the IR35 rules, the old rules. And essentially, if someone is working as an employee, they should be taxed as an employee and therefore should be subject to PAYE income tax, national insurance contributions, and apprenticeship levy. In order to work out whether someone is working as an employee, you have to consider a hypothetical contract. And essentially, what the tax legislation says is that you have to imagine that the worker is engaged directly by the end client, ignoring all of the entities and arrangements in the middle. And you have to look at that relationship in light of both the contractual provisions entered into in the supply chain, together with looking at what actually happens practically, i.e. on the ground, and throwing that all into the the melting pot. You have to ask yourself the question, would the worker be an employee of the end client if he or she was engaged directly by the end client? And if the answer is yes, then the worker should be taxed as an employee and subject to PAYE income tax and national insurance contributions. And this is only for tax purposes that the worker is treated as an employee. And if the answer is no, then the worker can use his or her personal service company structure legitimately and effectively take usually a small salary from the personal service company, and the main income would be taken out as a dividend from the personal service company. So the key takeaway from today is that the new off-payroll rules work in the same way as the existing IR35 rules. They both apply the same test in order to work out whether, if the worker was engaged directly by the end client, would he or she be an employee of the end client. But the big point that has changed is the responsibility as to who has the obligation to pay the PAYE income tax and NICs to HMRC. So one point I made in this slide is that if the rules apply, then the worker is treated as an employee for tax purposes. I guess, Tim, this raises in my mind whether, if you do conclude that the individual is an employee for tax purposes, does that necessarily imply that they would be an employee for employment law purposes?
Yeah, it's an important distinction to make here, because the answer to that is no, you wouldn't. The test and the process Mahesh is describing is one to assess whether, for tax purposes, the individual should be regarded as an employee and therefore taxed as an employee. The world of employment law is a separate world for these purposes and a separate question. The tests are, in the end, very similar, but what the cases say at the moment is where you have a PSC interposed between the worker and the end client, then employment law won't get involved to create an employment relationship. The PSC effectively diffuses that argument. Obviously, if there's no PSC and you're just engaging a contractor direct, then clearly you can have problems, and there may well be employment status for employment law purposes if there is for tax purposes. But if you have a PSC, then you wouldn't have a finding of employment law, which obviously creates a worst of both worlds situation for the worker. So not only would they be being taxed as an employee for tax purposes, they don't get all of the advantages and benefits that UK statute gives them as an employee. So there's a commercial point there, which obviously we'll come on to.
Thanks, Tim. So the next thing I really wanted to quickly do is just recap on the IR35 rules, i.e. the current rules and how they work. So here, the first thing we need to sort of note is that the obligation on constructing the hypothetical sort of contract between the worker and the end client rests on the PSC itself. So it has to do the analysis and conclude whether or not, if there was a direct engagement of the worker by the client, would the worker be an employee of the client? If the answer is yes, then it's the PSC's responsibility to account for the PAYE income tax and national insurance contributions, and that would include the employer national insurance contributions. And the way PAYE works under the IR35 rules is not on a sort of monthly basis in the way you typically see for sort of regular employees, but in fact the PSC has to account for the PAYE at the end of the tax year. In contrast, and obviously if the answer is no, that they're not a deemed employee of the client, then the PSC will just pay, will have no obligation to operate PAYE and draw its money out sort of tax efficiently. So the existing IR35 rules are good news from the end client's perspective, because there's no compliance burden, there's no risk of PAYE income tax or national insurance contribution liabilities, and all of the risk, if to the extent that there's a risk that the individual is an employee for tax purposes, squarely rests with the PSC. So end clients were actually quite happy to engage with personal service companies because it actually ensured that the risk lay elsewhere and not at its sort of doorstep. But obviously, for the reasons I've sort of set out already, this was bad news from HMRC's perspective, because they would have to look at each PSC and indeed each contract of each PSC in order to enforce the IR35 rules. So that's the problem with the existing rules. And I should say that the existing rules, as you will sort of see in a short while, sort of continue to be relevant. So how do the new off-payroll rules work? Well, the new off-payroll rules effectively change the situation somewhat. First of all, it's the end client that has the responsibility of constructing and analysing the hypothetical contract. And it's the end client that therefore has to answer the question, if I engage the worker directly, would he or she be my employee for tax purposes? And if the answer is yes, then it is the fee payer, and I'll explain who that is in a moment, that has the responsibility to account for PAYE income tax, employee and employer national insurance contributions. So who is the fee payer? Well, the answer to that question depends on the nature of the supply chain. So if you have a very simple supply chain whereby you've got the end client, you haven't got any agencies in the middle, and you've got the end client engages directly with the PSC, then the fee payer would be the end client. However, if you have the supply chain set out in the slide where you've got two agencies in between the end client and the PSC, then the agency most closest to the personal service company is the fee payer. Okay, so and that would be the case if you had more agencies above sort of agency 2 in this example. So one of the consequences of this is that the cost of employer national insurance contributions has now been moved. It was under the existing rules, the IR35 rules, sat at the PSC level, but under the new rules, it rests with the fee payer. Now, ultimately, commercially, what that really means is it rests with the end client. And the reason for that is that if you've got agencies in the way, then they are simply facilitators to the supply chain. They're not really receiving any services. The person receiving the services is the end client. And therefore, to the extent that there is the rules apply and there's an employer national insurance contribution liability, then the cost of that liability will rest with the end client, commercially speaking. So the rules have made two sort of important changes from an end client's perspective. First of all, it's increased the compliance burden on the end client, and secondly, it's actually imposed a cost to the end client. So perhaps just worth mentioning or asking ourselves a question here. Could we sort of circumvent or sidestep the rules if one or more of these parties were offshore? So what if the worker established their personal service company offshore? So it's not a UK limited company, it's a company incorporated elsewhere. That would not make any difference to the analysis. The next sort of question we could ask ourselves is, well, what if we put one of the agencies sort of offshore? Would that make a difference to the analysis? The answer is yes, but it only makes a difference in terms of changing who the fee payer is. It doesn't make a difference in the rules applying as designed. So if you had an agency which is offshore and doesn't have any connection to the UK, then effectively that agency would be ignored in determining who the fee payer is. So let's just say agency 2 was offshore for these purposes, then agency 2 cannot be the fee payer, and in fact agency 1 would be the fee payer, even though it's not the agency closest to the personal service company, but it is the UK agency or UK based agency closest to the personal service company. So there are implications of having offshore entities in the supply chain, which you need to be mindful of. But I guess we should just ask ourselves, well, why did the revenue design the rules in that way? Well, what the revenue are trying to achieve is effectively stopping end clients engaging agencies which are offshore, and therefore which would potentially open up an avenue to sort of beat the rules and therefore avoid the PAYE liabilities which the new rules are designed to impose. So having offshore parties in the chain will not really help you, and in fact will make the compliance with the rules sort of more complicated and potentially more onerous. So the next question we need to ask ourselves is, who do the new off-payroll rules apply to? So which types of clients do the off-payroll rules apply to? So as I've said already, the rules have already been in play for public sector clients. I appreciate that most people on this call will be private sector clients, so that's going to be the focus of today's talk. So what is a private sector client? And effectively, a private sector client is someone who's not in the public sector, and someone who is not small. And a small client for these purposes is a client that meets two of the tests set out in the grey box on that slide. So they have a turnover of less than or equal to 10.2 million, or gross assets on their balance sheet of less than or equal to 5.1 million, or employees or less than 50 employees over the course of a year. So if you meet two of those tests, then you're a small client. And if you're a small client, you don't have to worry about these rules because you're not caught by them. But in most cases, and especially for the kinds of businesses that we act for and are attending this talk today, they will be medium or large clients because they're not small, and therefore they do have to worry about these rules because they are an end client within the scope of these rules. So you could sort of ask yourself the question, well, what if I just incorporate a new subsidiary company which doesn't undertake any substantial business, doesn't have many assets, and doesn't employ anybody, and I effectively engage all of my personal service company workers through that new subsidiary company? Would that circumvent the rules? The answer is no. HMRC has obviously thought of that potential avenue, and what they have said is that if you've got a group, then you've got to apply these tests on a group-wide basis. So you've got to effectively aggregate the turnover, the gross assets, and the employees of the group when you're applying these tests, and therefore you are likely to come to the conclusion that you are medium-sized or large. And if you're a UK PLC, then you cannot be small, even if you do meet the two of those tests in the grey boxes.
Sorry, Mahesh, just a quick question
Yeah.
from me on that. You made the point that if a company is small, then the off-payroll rules won't be applying to you. But presumably there's a communication process still needed in practice, because whether the PSC knows that you're small or not small, and who's going to be either the old IR35 rules or the new rules, who's going to be sort of taking responsibility for that? So I appreciate not many people on the call will be small companies, but how would that work in practice?
Yeah, so good question, Tim. The worker does have the right to ask the end client whether or not it is small. And the reason why the worker is interested in asking that question, in fact, knowing the answer to it, is because if the client is small, then the individual's personal service company has the obligation to operate the existing IR35 rules. So just because a client is small doesn't mean that these off-payroll rules don't apply. It just simply brings you back into the current world where all of the burden rests with the personal service company, and it will be the person that needs to work out whether based on the hypothetical contract, they would be a deemed employee of the end client. And there is a sort of pro forma notification included in the HMRC guidance, which end clients can use in order to sort of make that sort of declaration to workers who ask that question. So next, looking at status notification obligations. So if you are an end client that's medium or large, you fall within these rules, you're engaging people, services through personal service companies with or without agencies being used to procure those services, what do you have to do as an end client? So as I said earlier, it's your responsibility as an end client to work out whether the rules apply, and you need to do that by reference to the hypothetical contract. So once you've done that analysis, then you need to issue a status determination statement to the agency and the worker. What the status, the SDS needs to say is whether or not the worker is within the rules, and it also needs to set out the reasons why the particular conclusion has been arrived at. Okay, so I guess when you're an end client doing that, I guess the first thing you need to do is work out whether the personal service company that you're dealing with is in fact an intermediary within the relevant definition in the tax rules. So most personal service companies will be intermediaries because they will be wholly owned by the worker, but there is a particular sort of test that needs to be applied in order to work out whether the PSC is in fact within the scope of these rules. And so that the end client can know this, the end client has a right to ask the worker whether or not the personal service company is in fact an intermediary caught by these rules, and the PSC and the worker have an obligation to inform the end client whether or not it is in fact an intermediary within these rules. So going back to the SDS, so we've said that the end client has the obligation, and we've said what it needs to say, but I guess the question is, what does the end client need to do in order to make its decision? What HMRC say in their guidance is that, and indeed the legislation, is that the end client needs to take reasonable care when they're making that assessment. And reasonable care in the guidance is explained as acting in a way that would be expected of a prudent and reasonable person in the client's position. So what does that actually mean? And the guidance sort of expands on this, and it says that what it means for a particular end client will depend on the sophistication of that end client. It will be viewed in light of the abilities, experience, circumstances of the particular end client. And it gives the example of a multinational company with its own finance function, and it says that it would expect a higher degree of care from such an entity as compared to a much smaller company which perhaps doesn't have that degree of sophistication. So I asked myself the question, what would that mean for a lot of our clients who are reasonably sort of sophisticated? They may not be sort of necessarily multinationals, but they'll be sophisticated, quite often clients in the financial services space. What level of reasonable care would HMRC expect from them? And I think, you know, it's not about size, it's more about sort of how sophisticated the business is. If it actually is a financial services business, for example, or used to dealing in complex sort of areas, it would be expected to have gone through a more sort of rigorous sort of process and have more rigorous processes in place in order to clear the reasonable care hurdle. And what the revenue sort of guidance also does, it actually gives you examples of factors which will indicate that someone has taken reasonable care. So, you know, things that you'd expect, sort of keeping good records, accurately completing the check employment status tool, which is HMRC's sort of status indicator tool available online, applying the HMRC guidance correctly, reviewing the processes applied, and importantly, because not all clients will actually want to do the status determination themselves, what they might do is actually outsource that to the agency or to a specialist provider. If they do that, then it's still the client's obligation to ensure that they sort of check and review the processes that the outsourcer is using to make sure that they are fit for purpose to sort of meet the standards of, required for reasonable care. And equally, the guidance sort of gives you examples of situations where the HMRC will say that reasonable care hasn't been taken. And for example, if a client simply makes a blanket ruling that particular individuals within a particular fact pattern will be sort of within the rules or outside the rules, then such a blanket sort of generalist approach without looking at the facts and circumstances of each individual is unlikely to pass muster. If the client hasn't given or put the sort of infrastructure and trained the relevant people to undertake the status determinations if they're doing it in-house, then again, that will be an example of not taking reasonable care. If you're putting inaccurate information into the check employment status tool, which is the HMRC status indicator, again, that's an example of not taking reasonable care. Or if going back to the outsourcing example, if the end client is not confirming the accuracy of the conclusion and the reasons for it in relation to each personal service contract, then again, that will be an example of reasonable care. So simply outsourcing is not good enough. I think end clients still need to, on a case-by-case basis, sense check the conclusion that's being presented to make sure that they're sort of happy with that.
Sorry, Mahesh, just on that. So, but presumably then the point is that if you haven't exercised reasonable care in making the decision, then the exposure, the obligations, if indeed there is a sort of deemed employment, that whizzes its way back up the chain to you. So you can't then rely on it being held down at whoever the closest person to the PSC would be.
Correct. Yeah. So even if you've actually made the right decision, so let's say you had taken reasonable care and come out with the same answer, if you haven't taken reasonable care, then the PAYE liability will rest with the end client and it won't sort of pass down the contractual chain. And in the last box, the end client should review the SDS regularly. So what I'm driving at there is that relationships with PSCs and workers sort of change over time. It may be that the terms of the contract are changed because the nature of the work required from the PSC is different to what was the situation at the outset, and therefore making a status determination is not just a once in a contract obligation. It's something that end clients need to be reassessing on a periodic basis, and that may be because something material has changed, or it may be that simply you need to sort of kick the tires on a regular basis in order to check that the original status determination continues to apply. So that's something that end clients need to be aware of. And I've been asked the question, how regular is regular in this situation? My personal view is once a year would not be a bad thing to do in relation to all of your sort of PSCs. Obviously, especially the ones where you concluded that they're not within the rules, because that's where the risk sort of really lies.
Mahesh, just on one of the questions in the Q&A box links into this. So in terms of reviewing the SDS, so if an organisation's done a determination in 2020, so let's say prior to the last deadline we were all working towards, so an SDS determination was made then, will there be a need to do a new determination ahead of 2021?
Not necessarily. So if all of the sort of facts and circumstances continue, then it is possible for that SDS to continue, or the original SDS conclusion to apply from the 6th of April next year. But again, I think whilst the guidance clearly states that the conclusion can sort of roll forward, if you did that a year ago, and going back to my sort of making sure that you're kicking the tires regularly, I would think that it's still prudent perhaps sort of February or March next year, just to check that things are indeed the same, and therefore the conclusion continues to apply. And again, I think in terms of the work needed, you can limit that to the situations where you arrived at the conclusion that people were outside of the rules, i.e. there was no PAYE obligation, because that's where the real risk lies for the end client. So looking at the SDS and notification obligations, so what actually, when does it need to be done by, and what does the end client need to do with it once it's made its decision? So there is no time limit by which the SDS needs to be done by, but sort of practically speaking, it should be done before the first payment is made under the contract. So given that these rules are now coming into place on the 6th of April of the year, I would say that you should do your SDS for contracts which sort of run past the 6th of April before that date. And obviously for any new contracts, you should do your SDS before the first payment under that new contract. Once the SDS has been made, what does the end client need to do with it? The end client needs to do two things with it. It needs to give it to the agency that it's contracted with, and it also needs to give it to directly to the worker who is providing the services under the PSC arrangement. Okay, and that is important because, as well as Tim, as you said, undertaking the SDS in the appropriate way, with reasonable care, it also needs to make these notifications to pass on the PAYE obligation to the fee payer. So the end client would give its SDS to the agency one, then agency one, in order to remove PAYE obligations from itself, would need to pass on the SDS to agency two. And agency two is the fee payer because there is no further agency in the chain. It is the one engaging with the PSC. So there's definitely some compliance obligations there, and I think from an end client's perspective, it would be good practice to get acknowledgement from the persons that it has passed the SDS onto, so that there is effectively an audit trail that it has complied with its obligations, and by doing so has effectively pushed the PAYE obligation down the chain. In terms of the form of the SDS, there is no prescribed form. We have got a precedent which we can sort of make available to clients for free. So if anyone is interested in a pro forma, let us know and we'll let you have a copy. So coming back to the timing of the new rules. So when do they come in force? Well, they were originally intended to come in force last April, i.e. the 6th of April 2020, and the new rules had been trailed for a good few months before April of this year, so that end clients and agencies and PSCs could get themselves prepared for their introduction. But very much as a last minute reprieve, the rules were delayed, and that was very much driven as a consequence of COVID. And so the rules will now come into force on the 6th of April 2021. And the new rules apply to payments and services provided after the 6th of April 2021. They apply to both existing contracts. So if you've got an arrangement with a PSC that's already in place and someone's providing services under that arrangement currently, and that arrangement will continue past the 6th of April of next year, then the rules will apply to that arrangement. So therefore you need to consider the application of those new rules to that existing contract before the 6th of April next year. And obviously the new rules will apply to new contracts entered into after the 6th of April next year. So one worry that people have had is that, what if you've got the situation where someone's been paid gross, i.e. their PSE has been paid gross, so far as the end client is aware, the PSE has not been operating PAYE, IR35 and therefore PAYE. How will that sort of historical position colour the prospective position if what has happened or what will happen prospectively is that a conclusion will be arrived at whereby the end client has decided that the worker is caught by the rules and therefore PAYE needs to be operated in relation to payments made to the PSE. So in that situation, what HMRC have said is that they will generally not look back at the historical sort of position and any information relating to that period in based on the decision arrived at under the new rules. However, HMRC have sort of caveated their position in that, if something nefarious has happened, then they will reserve their right to look at the historical position based on the outcome of the application of the new rules. So if there's some criminal behavior or fraudulent sort of behavior suspected, then HMRC will reserve their right to look at sort of the historical position and challenge the PSE and its obligations in relation to compliance with IR35. But again, I think from the end client's perspective, that shouldn't be a problem. That really, if that does happen, that's likely to be a problem for the PSE and the worker only. So in terms of the new rules, I've already sort of touched upon this. The three sort of grey arrows effectively set out scenarios when the rules will apply or won't apply. So if you've got on the top line, you've got an arrangement where services are being provided, the contract's due to come to an end before the 6th of April next year, and it may be that there is sort of one or more payments in relation to historical services which are made after the 6th of April of next year. In that situation, you don't need to think about the new rules because the services were provided before the new rules come into effect on the 6th of April. It doesn't matter that payment for those services is made after the 6th of April. In contrast, if you've got a situation where both the services and the payments are made or provided after the 6th of April next year, then you're squarely within the new rules and you need to think about them. Now, it may be that, there's a straddle period whereby some of the services, for example, for the month of April, relate partly to the period sort of 1 to 5 April, and then the balance for 6th to the 30th of April. In that situation, it's only the payment relating to the services from the 6th to the 30th which are caught, and you can apportion on a sort of just and reasonable basis in order to make that determination if you weren't operating PAYE for the pre-6th April period, but you've concluded that you're within the rules and have to operate PAYE for the post-6th April sort of period. And clearly, the other sort of more straightforward scenario is you've got an existing contract, it comes to an end before the end of the current tax year, i.e. 6th of April next year. You don't have to worry about the rules there. You can just ignore them for the purposes of that contract. Right, could the rules be delayed again? So for those of you who have attended a similar seminar in the past, I think I've certainly been asked this question a couple of times, and I've sort of, before COVID and the delay, I categorically said there is no chance that HMRC will delay these rules. And then obviously Rishi Sunak made the announcement just before the rules were due to come into force and delayed them. And so, it's a reasonable question to ask. And I think in the current sort of situation, I think there is a thumb sort of clearly pressed down on the side of the scale, suggesting no, there will be no delay. And I think this time round, the legislation has been enacted, the government said it won't sort of cancel or delay the rules. And, as I said already, the rules apply in the public sector. And therefore, to level the playing field between the public and the private sector, I don't anticipate a delay, but you never know. But one of the reasons why I don't sort of anticipate a delay is actually sort of COVID related, in that, clearly, I think the Chancellor wants to balance the books. I made the point at the start that this is potentially worth £1.3 billion to the Treasury, and therefore the sooner that they can get the rules in play, the sooner they can be collecting that sort of missing 1.3 billion in their minds. And I guess we need that now, perhaps sort of more than ever. So in terms of the introduction of the rules, a few sort of recent changes worth mentioning. The rules don't apply to private sector clients which have no UK connection. I will touch upon that in a second. The rules on recovering income tax from non-fee payers, have been introduced. So what I said earlier is that, provided the end client complies with its obligations, whereby it takes reasonable care in making a status determination, it passes on that status determination to the agency and the worker, then effectively it absolves itself of the obligation to account for PAYE income tax and national insurance contributions. So it's not the person that's operating payroll. However, there are circumstances in which if the person who does have that obligation, i.e. the fee payer, fails to comply with those obligations, then the liability can sort of pass back up the chain to either agency one on this slide or the end client. And we can go into those rules in a lot more detail in a further session, but I think the point really worth making there is that, whilst the end client shouldn't have a liability, there are circumstances, especially ones where the agencies have been promoting a tax avoidance scheme to try and effectively sidestep these rules, where that liability could sort of pass back up to the end client. So again, end clients need to do their due diligence as to what agencies will or won't be doing so far as payments are concerned, and ensuring that they're actually entering into contracts with reputable agencies who will do the right things and comply with the legislation as designed by HMRC, because that's what the revenue are looking for here. They are looking for compliance with the rules which they believe that have been in play for 20 years and just haven't really been complied with by the PSEs that have been responsible for operating them. There is legal obligations on clients to say whether they are small if asked by an agency worker. That's the question that Tim asked earlier. And there have been improvements to the client-led sort of disagreement to the process. So let's have a quick look at some of those points. So I talked about the rules not applying to clients which have no connection with the UK. So they're wholly abroad, in other words. What does a connection mean for these purposes? Well, you'll have a connection with the UK if you're UK tax resident, or you'd have a connection with the UK if you have a UK permanent establishment, and a client should know whether it's got a UK PE, because that's a question it should be asking itself for other reasons. Whether a client has a UK connection needs to be considered immediately prior to the tax year that you're sort of considering. So in relation to the rules as coming into force on the 6th of April next year, you'd be considering it on the 5th of April. So if you are a client that does not have a UK connection, then you're not a client within the off-payroll rules, and therefore you don't have to apply the off-payroll rules. However, that doesn't mean that the off-payroll rules don't apply. What that means, in the same way it would mean for a small client, is that the individual's PSC has to apply the existing IR35 rules. And sort of final point, in relation to the situation, we don't need to apply the connection test on a group-wide basis. It is an entity-by-entity test that needs to be applied.
So, Myers, just a quick question that's come in on the no UK connection. Asking about a situation where both the PSC and the worker are based offshore, so the worker is working remotely.
Yeah, good question. In that situation, as I said earlier, it actually doesn't matter where the PSC is. That's actually a red herring in the analysis. If, in contrast, the worker is offshore and is undertaking all of their duties of employment offshore and isn't subject to a UK tax liability, in the same way that would be the case if the client had engaged a worker offshore, it just happened to be a UK employer of an offshore worker, then there shouldn't be a liability, a PAYE liability under the rules, and therefore effectively they're not in play, because even though theoretically they might apply, because there's no end of the day tax liability for the duty in relation to the duties of employment, you don't have to worry about the rules. Okay, what should you continue to do? So these are just sort of things that you should have been doing in the lead up to the previous introduction of the rules, and therefore, you know, we need to be sort of thinking about again. So, you know, in the lead up to the 6th of April, you need to review all of your engagements with PSCs where they're not being paid through PAYE, and you can do that using the Check Employment Status tool that HMRC provide, or a similar tool, and there are a few out there in the market. You need to check that the contracts reflect how the engagements work in practice, because, as I said earlier, the hypothetical contract looks at both the contractual provisions as well as what happens on the ground. You need to gather all of that information and come to an SDS decision, and you know, issue that SDS to the agency and the worker before the 6th of April next year. Now, it may be that as part and parcel of that process, end clients decide that actually, you know, it wants to migrate someone to a permanent employee role, or require them to operate through an umbrella company, or ask them, the agency, to effectively operate payroll in relation to payments being made to that individual. So, you know, we have seen in the lead up to the original deadline a real sort of change in behavior in terms of end clients as to how they want to engage sort of contractors. And I'm certainly aware of a number of the big sort of investment sort of banks who have effectively taken a sort of policy decision not to engage individuals through PSCs, and either engage them as sort of permanent employees or through a third party. I guess, Tim, a question for you there. You know, why would I, as an end client, decide to take someone on as an employee, or in contrast, why would I want to take them on through an umbrella or as an agency worker?
Yeah, I suppose if you are you're taking the leap and engaging somebody as an employee, you take on board all of the obligations and responsibilities that go with that. It's obviously not a major thing in the sense that lots of organizations have lots of employees, but obviously, you know, employees have lots of rights, and letting them go, you know, you don't have the same sort of flexibility that you would do if, for example, you are engaging people through an agency or through umbrella companies. I think perhaps also a lot of organizations, although it seems a bit formulaic. A lot of organisations will have headcount caps on FTEs, on full-time employees, and often bringing people in through agencies is a way of maybe going around internal requirements around limits on permanent employees. So yeah, there are clearly advantages around flexibility and limited exposures if you're going through agencies, but there are clearly downsides too.
Thanks, Tim. And I guess sort of one of the decisions that when you're looking at this is, if you are looking at alternative arrangements, is actually just pricing those, because if you're taking someone on as an employee, then you've obviously got the employer NICS sort of cost, and that's going to be on top of the cost that you might already be incurring in terms of the gross fee paid to the personal service company, if you decide that the gross fee equates to the salary that you're going to offer to the worker if you engage them directly. So I think there are some commercial considerations that sort of need to be thought about when considering what alternative arrangement you might engage someone under, as opposed to the PSC structure. So status disagreement process. So this is the last point that I sort of wanted to talk to. So what happens when the end client issued an SDS, and that SDS says to the worker that we think you are caught by the rules, and therefore any payments made to you from the 6th of April next year in relation to services you provide after that date will be subject to PAYE income tax and national insurance contributions. Workers likely to be sort of unhappy with that sort of conclusion, because that's going to mean that the effective tax rate that they were getting money from their personal service company is going to go up significantly to employment taxes, 45% top rate, plus 2% national insurance contribution, so an overall sort of rate of around 47%. What can the worker do? Well, the clients are required to have a disagreement process in place, and the worker can utilize that process in order to challenge the SDS. And in order to challenge the SDS, the individual can make written or verbal representations as to why it thinks the end client's decision is misguided. And this actually comes back to one of the things that the end client needs to do in relation to the SDS. The end client needs to state the reasons why it arrived at its conclusion. And it would be those reasons that I would expect workers to challenge. Say, well, no, I think you've got, that reason doesn't apply to me for, for the following reasons. And if that does happen, then the end client must respond to the worker's challenge within 45 days of the date on which the representations are made. Now, I actually just said that the worker's challenge, but in fact, the person that can instigate the status disagreement process is both the worker or the deemed employer or the fee payer, agency 2, in the supply chain on the left. And in order to make sure that you've got a process which is a fit for purpose, the end client's got to consider the representations and effectively set out its reasons why its conclusion continues to apply. So its original conclusion that we think you're caught, or set out its reasons why it has decided to change its SDS. And obviously, if it does decide to change its SDS, then it's got to take reasonable care. And therefore, I refer you to my discussion earlier in giving the new status determination. And I think the final point I wanted to make on the disagreement process is that it can be instigated at any time. So both before the contract starts and in fact during the contract. And why so? Because, I said from the employer's perspective, the end client's perspective, that, they've got a duty to look at the contract throughout its life, because material changes could mean that the original SDS needs to be reconsidered. And I think that also applies from the worker's perspective, because it could be that the workers noticed that now the arrangement has moved such that the thing that was impacting their status as being caught has now sort of moved out of the contractual relationship, and therefore there is a possibility that they could be categorized as outside of the rules sort of going forward. So you may find that workers throughout the life of a contract instigate the disagreement process.
Sorry, Miles, just a quick question about the disagreement process. Obviously, it's possible that within those sort of 45 days and the discussions and representations that happen, the sort of a mutual agreement is reached as to the position one way or another. What's going to be the position, though, if you get to the end and there still is disagreement, nobody's managed to persuade the other of the position? What happens then?
Okay, fair question. Well, I guess sort of two things can happen. So one could be a very sort of practical one, which is, they decide that this is not an arrangement sort of worth continuing with, because it's not going to work out for the personal service company and its worker. Now, obviously, I think in that situation, end clients need to think about what contractual right they have in order to require the worker to continue with the contract. And so that's the sort of more practical point. But from a tax sort of perspective, what can the worker do? I mean, first of all, it will have to accept that payments made to it by the fee payer will be subject to the deduction of PAYE, income tax, and national insurance contributions. But it could, when it files its self-assessment tax return, effectively claim a refund for the deductions made, and the basis for that claim would be the end client decided that I was caught by the off-payroll rules. I don't think I'm caught. I think the end client got their analysis wrong, and therefore I'm claiming a refund for the PAYE that was deducted, but which shouldn't have been deducted. So that's, I think, a theoretical sort of possibility. And the reason I say it's theoretical is that, I don't really see HMRC agreeing to such refunds when, HMRC has historically thought that more PSEs should be admitting sort of PAYE liabilities in these types of situations, and that they've effectively got someone else, which is not HMRC, that's decided that someone would be an employee had they been engaged directly by the client. So I think, whilst it's possible, the individual's got an uphill battle, and I wouldn't really fancy their chances.
Yeah, okay.
Tim, I've sort of spoken about how the new rules work and all the sort of various nuances in terms of compliance. But one of the issues I talked about was, putting all the factors into the melting pot, in order to work out whether someone would in fact be a deemed employee or not a deemed employee of the end client under the hypothetical contracts. Do you want to take us through what factors that need to be considered?
Yeah, no, absolutely. And this is where there's quite an interesting overlap, I think, between the world of employment law and tax law, because although we're making determinations for tax purposes, tax tribunal purposes, there is a great deal of overlap between the concepts at play here and the cases that are assessed and form part of it. I think the first thing to say is that this is an incredibly difficult test to apply. That there are lots of factors that get taken into account. Not one factor is determinative. There's not a sort of statutory test that you simply apply, and it's built up from multiple tax cases, layering on employment cases as well. So we've listed out on the slide there some of the key factors that the tribunals will consider when looking at the status determination, or that you will be looking at when you're making your status determinations too. So written agreement, having a contract in place, that's a very useful starting point, because as Mahesh says, when you take away the PSC or any sort of intervening bodies between the end client and the worker, the assessment is what the terms of the engagement are, and the written contract in place at the moment will form an obvious starting point for that. But clearly the courts are wise to the idea that you just serve up what they want to see, and the point there, substance over form. They won't just rely exclusively on the terms. They will look at what's happening on the ground, if that isn't a sort of a genuine representation of what's actually happening. And one of the questions that came in on the Q&A was about status determinations and contractual wording, where, for example, the wording talked about being able to substitute alternatives to do the work. And if in reality that simply wasn't the case, then the courts would see the drafting in the contract, but would go with what happens on the ground. Obviously, you want your contract to reflect what happens in reality, but the courts will look beyond it where they have to. Control, that's a big one, I think, out of the different elements. The amount of control the end client has over what is done, how it's done, when it's done, where it's done. I think it becomes slightly less important when you get into more highly skilled workers, but the amount of control that you have is a key factor. As is the right of substitution. I've touched on it. So high levels of control would indicate employment status. Personal service, the fact that I am the person who has to do this work for you, is an indicative factor of employment, as opposed to if you don't really mind who's doing the work, you just need somebody to come in who does it, who's qualified. And if that happens, then that is more indicative of not employment of self-employment. Similarly, provision of equipment. Does the end client provide everything the individual is needing or using to do the job, or do they provide their own equipment, their own materials for the role? That would be more indicative of self-employment. The risk and reward element for the worker. If I'm engaged in a way that if I work efficiently and quickly and things go my way, then I might make more money out of this. It might be a more profitable return for me on my investment as a worker. That's more indicative of self-employment. Similarly, if I carry a risk that it takes more time than I thought it was going to take, and I'm a bit more out of pocket, that sounds like self-employment, as opposed to I'm just paid a regular, steady daily rate. And I'm not really exposed to risk or reward. That would be more indicative of employment. Mutuality of obligation, another key element in employment status tests. Am I obliged to do the work when you ask me to do it? Do you have an obligation to offer me work? Those are sort of key features of an employment relationship. Do you give someone employment-related benefits? Hopefully not. But if you're giving people things like sick pay, holiday, the sort of benefits you normally associate with somebody who is an employee, that would be an unhelpful factor. How are they treated in terms of the organisation? Are they part and parcel of the organisation? Lots of different elements here, but do they come to work functions, employee functions? Do they have their own business cards with the company name on? How are they represented to internal parties, to external third parties? Is their status made clear in that environment? Length of engagement as well. I think a number of the tax cases make it quite clear that long, regular engagements are more likely to be indicative of employment status. That's not to say that you couldn't have self-employment over a period of time, but a long engagement is not going to be helpful. And the intention of the parties as well. Again, presumably the parties' intentions will be that it's self-employment and not employment, but the courts will look at that. And as I said at the start, there are lots of cases on this area, lots of different elements that go into assessing how it's that the status is assessed, and it's not straightforward. Again, one of the questions that came in on the Q&A is about an individual who has a PSC but provides services to multiple clients. That I think is probably a helpful factor. I mean, if you're trying to present a picture to HMRC that what is being provided to the end client in this situation is where the end client is a client of that PSC as opposed to really just employment, the fact that the PSC is working for other organizations will probably be helpful in some of these other factors, but will be a supporting factor as well. Another question that came in on the Q&A is around the amount of the FTE provided by the worker and whether that's a factor. I think that probably feeds into the sort of, the concept of length of engagement or intensity of engagement. You know, if I'm working for you 5 days a week, Monday to Friday, 9 till 5, you know, I'm starting to look and smell a bit like an employee, and that will be an unhelpful factor. Now, it's not to say that somebody who works for you 2 days a week can't also be an employee, because you can have part-time employees as well, but it starts to paint a picture, and in an unhelpful way, that the cases do talk about painting a picture and looking at the overall image. So that was the relevant factors. That the CEST tool that we've talked about is meant to be a sort of distillation of those factors. And when you go through it, as I'm sure many of you will have done, you will have seen that those sort of issues being drawn out there. Practical steps to prepare for April next year. We've touched on a number of these. So carry out a contractual review. So work out who your contractors, your consultants are, those operating through PSCs, but I guess always good to be thinking about the ones not operating through PSCs anyway. Think about refreshing your SDSs that you've already issued. Has anything material changed? You don't have to just for the sake of it, but it may be worth revisiting those that are a bit more dated. Consider transitional provisions in your contract. So if you do have a pre-existing contractual arrangement in place and you are now concerned about the position in relation to that individual, revisiting the contracts, bringing it to a head now, having discussions around varying those terms to provide you with the protections you would need in the event that you were going to be applying deductions now, having made an employment assessment, or if you were to make an employment assessment. Reviewing your internal procedures, so thinking internally about who's responsible for this area. Where does responsibility sit? Is it with HR? Is it with legal? Or does it sit somewhere else? Who's going to be doing the assessments? And as stated there, reviewing your appeals processes as well, the status determination, disagreement process. Final point on this slide to talk about is around insurance, and just really to mention that there are organizations out there who provide insurance products in relation to this area. So effectively, you would do a form of SDS through either the insurer or an approved process by the insurer, which would give you a determination. And then, assuming it was a determination that supported the self-employment arrangement continuing, a determined non-employment status for premiums, which I think seem fairly modest. For premiums, you can have insurance cover that would, in the event of HMRC challenging your determination, deciding that tax was due, would cover the tax and also related professional fees and costs associated with that. So depending on the number of contractors you have, depending on the sort of risk appetite you have, depending on how close you think you are to that middle area, it is possible to consider insurances. And then finally, impact of the proposals so far, just very quickly, 1 minute on this. Marsh and I were sort of kicking this around before. Obviously, a lot of you will have done work in advance of April this year, getting ready. Some of the things I think we think we might be seeing from our clients, fall in available work for contractors. I think it does seem from a number of our clients that they are closing the pool of work available to contractors, either going to bring people on as employees or looking to get things through agencies or umbrella organizations. As we talked about, employment contracts bring their own challenges, and some clients are prepared to do that, others are looking at different solutions. And also there may be a slight sense out there, again, we'll have to sort of see how this plays out, as to whether contractors themselves are sort of deciding to rebadge and find engagement and work through different ways, whether through employment or other organizations, and whether there's a sense that there are fewer contractors out there looking for work. So it will be interesting to see, probably with the availability of some hindsight, how the new regulations have impacted the way that the working market is going. Mahesh, I didn't know if there's anything else you wanted to add on that front before we wrapped up.
No, I think my sense is, and I think you touched upon it, Tim, that the appetite of end clients to engage contractors has reduced, and I think from a tax perspective, I think reputation is coming into play, because I think there are a number of end clients who have made policy decisions not to engage contractors who are effectively trying to argue self-employed status through sort of personal service company arrangements. And I think that's a sort of interesting sort of emotional change of opinion, as opposed to sort of a technical one. But that said, it has been driven by these technical changes, which are the off-payroll rules. So they're clearly having the desired impact from HMRC's perspective, which is effectively to close down a fair proportion of what were previously self-employed arrangements via PSEs.
Yeah, great. Well, I'm conscious we've ticked a couple of minutes past 1:15, so we will bring things to a close then. Just to say thank you very much to all of you for attending and joining us. Thanks to those of you who have posted questions as well. And Mahesh and I look forward to catching up with you all again sometime soon.
Thanks, everyone.